So for the past few days, there has been a lot of discussion around surveillance, privacy, kind of the balance of security and freedom. And this is actually quite pervasive in a lot of litigation and legislative proposals. So I'm going to toss it over to Amanda and say, can you give us kind of for those who aren't following, kind of a brief overview of some of the cases and proposals out there that you see that you're being active on and the industry is being active on concerning privacy and surveillance?
Yeah, absolutely. And as you said, I think that the Fourth Amendment actually comes up pretty often in this space because of the space's focus on financial privacy. And one of the ways that it comes up most often is in mandatory reporting obligations. So a recent example of that would be the IRS proposed rules related to brokers. And when I say mandatory reporting obligations, I just mean anytime an individual or a business is mandated to report personal or financial information to the government. So for example, if a centralized exchange is required to report a user's personal information to the government, that's a search. That's a search of that user's information, and that implicates the Fourth Amendment. So that, like I said, came up with the IRS proposed rulemaking. It will also be at issue when the change to 6050I, a provision of the tax code, is actually effective in January, and that will require reporting of transactions over $10,000 in trade or business with a criminal penalty for failure to comply. So the idea of a mandatory reporting obligation has both Fourth Amendment implications and criminal penalty implications. So if you're wondering how you challenge that, there's a good example in the case of Harper v. IRS. Not exactly a mandatory reporting obligation, but somewhat similar. So in that case, Jim Harper used Coinbase from 2013 to 2016 to transact in Bitcoin, collect income, and he reported those transactions. He paid capital gains on those transactions. And unbeknownst to many Coinbase users, the IRS sent an administrative summons to Coinbase seeking personal information, financial information related to a category of users. So an administrative summons means there's no suspicion of criminal wrongdoing. They are simply saying this category of people, you are required to give that user information over. Coinbase fought the summons. They successfully got the summons narrowed, and then the IRS actually sued Coinbase to enforce the summons and make them comply. 8.9 million transactions, information related to those transactions went to the government, and then over 10,000 people received letters from the IRS saying there was an issue with your tax reporting. So Jim Harper sued the IRS to bring Fourth Amendment allegations, Fifth Amendment allegations, and to challenge the constitutionality of the tax code provision that the IRS used to send that summons. Unfortunately, he lost at the district court, but that is up on appeal in the First Circuit right now. We put in an amicus. A lot of people in the industry were paying attention to that, put in an amicus, and that's something that we're avidly watching.
Got it. So Peter, I want to ask you about the Bank Secrecy Act and kind of help people understand what the rules are as they apply to traditional finance and why they should or shouldn't apply that way to crypto.
Sure. So, oh wow, I'm loud. The Bank Secrecy Act is what we would call a mass surveillance statute, but you'll more commonly hear it referred to as an AML KYC law, a rule that says that financial institutions so defined need to collect certain information about their customers, keep it on their books, and then report it to the government in certain given scenarios. For example, suspicious activity reports, where you have a transaction above a certain threshold, 2,000 or 5,000, depending on the kind of institution you are, and you notice something unusual, but there's no statutory definition of suspicious activity. It's just sort of like, well, it's a risk-calibrated standard, so if the bank thinks that you're doing something strange, they file a report. The Bank Secrecy Act goes back to the 1970s. It was passed into law, and it was challenged very rapidly, actually, in the courts. And the courts in California Bankers Association and Miller and a few other cases that followed said, actually, this is pretty constitutional, which is interesting because this is all warrantless data collection, and sometimes in large bundles. One thing that I think is worth noting, though, is that the courts in those cases originally found that it was constitutional as applied in the 1970s. And a lot of those thresholds have become much lower, if you will, because of inflation. And the number of reports has grown massively because of the addition of suspicious activity reports, which weren't in the original, and the fact that the Treasury Secretary can effectively request any kind of information under their statutory authority. They've broadened that since the 70s. And also, I would point out that back then you didn't make that many transactions with your bank. In the 70s, you maybe got a mortgage, you got your paycheck maybe cashed at a bank. Today, you make almost all of your transactions through financial institutions. And then the other thing I'd add with respect to crypto is this is a regime predicated on surveillance through intermediaries, right? So you have banks, eventually you have other financial institutions because that category can be expanded, and it has been expanded through rulemaking and through other processes to include casinos and all kinds of other things. But at least these are all centralized intermediaries, right? And so we're going to get into the Fourth Amendment implications shortly. The argument is, well, this is constitutional because people are willingly handing their information over to a third party, and they give up their expectation of privacy, right? But in the crypto context, there's a lot of activity that's done peer-to-peer, truly. Now, sometimes maybe we oversell that, but that is fundamental to the technology. If these systems aren't at some level peer-to-peer, what are we building except a better version of FedNow, maybe, you know? And so in the context of financial transactions that happen without intermediaries, you have this new question. How do you apply what has become something that's been sort of taken as rote, that will get all this information about financial transactions, to an area of activity that doesn't have the intermediaries you'd normally get the transactions from? Which brings us up to today, where we have things like the broker proposal, which is not under the BSA. It's about tax reporting. It's in the tax code. But they're similarly looking for intermediaries. They feel like they're not getting enough information about capital gains and third-party reporting, and so we're going to deputize new persons in the space to collect this information. And then Deputy Treasury Secretary Diego yesterday announced, you know, maybe we'll classify some other entities for the purposes of BSA reporting. So the BSA comes right into play here with respect to who else can we find in crypto that we could get this information from? And that leads to all kinds of hard constitutional questions.
Yeah, I can tell you a lot of peer-to-peer transactions happen on the Uniswap protocol and the Uniswap wallet. It's where I work. So we began with, you know, kind of what's going on in crypto, tracing it back to the banks. Paul, I want to turn to you and ask you about the Fourth Amendment itself, right? How does the Fourth Amendment affect the law in this area, and what's the history and what's it trying to strike a balance between?
Sure. So, I mean, I think in understanding the Fourth Amendment, it's important to understand that it really is just like a completely general provision. So it's been around since the framing of the country. It affects, you know, it protects your papers, your property, and your effects. And so it's not designed for any one particular space. It's not designed, you know, if you think about sort of some of the stuff that Peter was talking about, you'd almost start to think there's like a financial transactions exception to the Fourth Amendment, and there's not. I mean, and so, you know, and you might, if you talk to a government regulator, you might also think that they have some sort of adverse possession rule that if because of the happenstance of Fourth Amendment doctrine, they used to get certain information, they sort of think they have an entitlement to that, and they can sort of change the law to make sure that they don't lose some pre-existing entitlement to a certain degree of transparency. And none of that's right. And so you really start with the Fourth Amendment itself, and, you know, presumptively, information that the government wants, that it doesn't have, really should have a warrant before it can get it. But the reason that the Bank Secrecy Act was upheld, at least as applied, and at least in its 1970s version, was this kind of pernicious notion of the third-party doctrine. And, you know, and unfortunately, I think there's probably like roughly three at a minimum justices that probably have a view of that which is essentially not much more sophisticated than once you no longer have some paper or some information and some third party has it, you no longer have Fourth Amendment protection vis-a-vis that article. Now, at some level, that can't be right, right? Because if I put my papers and effects in a safety deposit box, like that's at the bank, it's in the hands of a third party, but I think even the government would recognize that I still have privacy protection for my effects, even though they're in the hands of a third party. And so I think where the debate on a lot of these issues is going to end up being resolved in the Supreme Court is not so much, you know, do you have any privacy interest in this information at all? Of course you do. but is that somehow significantly diminished just because it's in the hands of a third party? And I guess what I'd say is, my sense is that a working majority of the court is not going to say it's that simple. It's not going to say that it's as simple as if it's in the hands of a third party, you don't have any Fourth Amendment protection. And then what I find really interesting then is, the way this doctrine is kind of originated is, well, it's third party plus the fact that it was necessary for the business transactions that you voluntarily undertook. And so, the banks have to give over certain bank records that are because they're like the names on the checks, but you can't really write a check without putting a name on it. So it was necessary. But what's happened, I think, and Peter can speak directly to this, but the government, all of a sudden, because they have this seeming exception, then they want to impose requirements that aren't necessary to the transactions. They want to just go in and say, well, we're going to impose this requirement. It's now, as a matter of law, if you want to do a certain transaction, you have to give over certain information, and they still say they're going to get an entitlement to that without a warrant or going through the normal processes. So I think those will be really interesting questions that'll get teed up for the Supreme Court probably before too long.
All right, so for those who don't know, Paul has argued 100 Supreme Court cases. He's kind of the Taylor Swift of Supreme Court litigation. So I'm gonna follow up with you again. You say reading the tea leaves. What are some of the cases that have come before the court recently that have been decisions that would make you think that, hey, maybe the third-party doctrine isn't quite as robust as some in government wish it was?
So the big case, but it shows that sometimes it takes a while because it's been a couple of terms already. I think the big case is the Carpenter case, and the Carpenter case arose in the context of basically the signals that the cell phone sets off that helps either the phone company, but also potentially the police, figure out where you are at any given time. And then if the phone companies do sort of take that information and store that information, and so the police essentially requested that information in an effort to figure out essentially whether a suspect was within certain areas where there were robberies or other criminal activity. And they were trying to do that without a warrant and just through a subpoena to get this information from the telephone companies. And almost all the lower courts sort of applied this kind of simplistic version of the third-party doctrine and said, phone company. The phone company doesn't care about these records. It's not invading the phone company's privacy. And so, yeah, you can get them. Government, you can get them from the phone company, full stop. Goes up to the Supreme Court, and the Supreme Court, 5-4, though one of the four is no longer on the court, but 5-4 says, no, this is a Fourth Amendment problem, and it's not that simplistic version of the third-party doctrine is not our law. And there's a narrow reading of Carpenter, which really focused on the idea that, well, there's something kind of particularly private about sort of the full scope of all of your locational data. And and I'm sure the government, as these cases will get litigated, will say, yeah, Carpenter's just a case about that. If it's not about sort of where you were at 9:57 on a certain Thursday, then the Fourth Amendment still doesn't apply. But I think the fairer reading of the decision is that a working majority of the court has a more nuanced version of the third-party doctrine and is going to basically be pretty demanding of why is it, do you really need this information as an integral part of the transaction? And even if the answer is yes, do you still nonetheless have some reasonable expectation of privacy in that information?
The one thing I'd add is, so I hate politics. So you might ask, well, Peter, why do you live in D.C.? And it's because I love the law. And so to me, the most interesting moments are when you find an issue where people are very interested in the legal details and the normal political alignments, say, of the justices aren't where you expect them to be. There's some liberals on one side, there's some conservatives on the other. And Carpenter is one of these cases, because one of the dissenting justices is Justice Gorsuch. It's a Sotomayor majority opinion, I believe. And Gorsuch is writing a dissent. He doesn't come right out and say he'd actually agree with the outcome, but he basically says, the reason I'm dissenting is because the majority is trying to keep Smith and Miller on life support. And those Smith and Miller cases, those are the cases that establish the third-party doctrine. He actually used the term keep them on life support. And so you have a dissenting conservative justice here from maybe a more liberal justice's majority opinion saying, I think they just didn't go far enough. I'd like to completely review the entire third-party doctrine rather than have this nuanced carve-out. And so you find these interesting political alliances. This is not a left or a right issue. This is people who care about privacy, and this is people who, I think, on both sides of the aisle, realize that as more and more of our information is stored on third-party servers, as more and more of the things that we do in our lives happen with a third party, the exception from the warrant requirement has swallowed the entire warrant requirement. And we no longer have our constitutional privacy rights that we have in this country.
Talking about the kind of bipartisan nature of this on both sides of it reminds me of when Congressman Ammori was speaking earlier today, and he referred to an online activism campaign around the infrastructure bill. The group that led that activism is Fight for the Future, which is here somewhere, which is definitely on the left. Time Lemmer is definitely on the right. Right? But they agreed on this, and so you see these strange bedfellows. And you also see an interesting thing where, I remember when the Patriot Act came out, and the left was just up in arms. How could you give the Bush administration, all this power, right? But now, we had Deputy Secretary Adeyemo come here and ask for, tons of financial surveillance power. So the shoe's on the other foot in some ways. Amanda, in the brief that you wrote in the Harper case, you make some arguments that are similar to the ones Paul was alluding to around the breadth of information gathered. Do you want to sort of walk through, because I think it helps explain why crypto might be different, right? If they're not going to get rid of Miller and Smith and keep them on life support, you guys, you think we can still distinguish those cases?
Yeah, absolutely, because I think that the government's argument is premised on the assumption that cryptocurrency transaction records are the same as TradFi bank records. So they're using the doctrines that both Peter and Paul were just talking about to say that if these transaction records are like bank records, then under the third-party doctrine, there's no Fourth Amendment issue here. We have long held that bank records searching through bank records is not an unreasonable search. But as we know, cryptocurrency transaction records are not like bank records. So in the Harper case, for example, Coinbase collected information to give to the government that included on-chain activity. So from Coinbase activity, they included counterparty information, wallet address information on-chain. And once we're talking about on-chain activity, we are talking about an infinite supply of information that does, in fact, reveal the intimate details of a person's religious life, familial life, political donations, whatever it might be, for all time. So I think that what the government failed to articulate there, or failed to appreciate, was that we are not talking about bank records. We're talking about a different beast, which I think defeats the third-party doctrine argument and does bring it back under the Carpenter argument that you were just talking about. And it is actually more like Carpenter, not less like Carpenter.
So, Peter, I'm curious your thoughts on the statement or the Treasury proposal made a few days ago that was presented by Deputy Secretary Adeyemo yesterday. The proposal was pretty wide-ranging, including a request for a grant of extraterritorial jurisdiction over foreign issued stablecoins, expanding the BSA to essentially technology beyond financial institutions. What's your take on it? Because just for the non-lawyers, essentially there's a hierarchy of law. So if an agency adopts a rule, it could be struck down because it violates the statute enabling that rule. And the statute was passed by Congress. And if Congress passed a law that violated the Constitution, it could get struck down. Right? So the Fourth Amendment is constitutional, can strike down any law. And so I'm curious your thoughts on kind of the constitutional analysis if a statute like that was passed.
Yeah, so I mean, there were a couple of aspects of the Deputy Secretary's proposal that I found puzzling. The first was the statement that there were, so that he used the term sort of half-century-old definitions don't afford us the discretion we need or the powers that we need, which I think was very interesting because the Bank Secrecy Act, this is a little bit off topic because this is a Fourth Amendment panel, but I think possibly the biggest constitutional infirmity of the Bank Secrecy Act is that it's an incredible broad grant of authority from Congress to the agency, which from separation of powers standpoints is also potentially unconstitutional. Congress is solely vested to make laws, and very consequential policy decisions should be made by our elected representatives and not by appointed persons within the executive branch. And the BSA, if you read it, if the statute as it currently exists is what we're looking at, it affords the Secretary of Treasury almost unlimited power through rulemaking to declare anybody a financial institution. Anybody whose records are useful in criminal or tax investigations can be classified as BSA regulated, as a financial institution. And so my first question is, why do we need Congress to actually act to give the department more power to create more financial institution regulations when they seem to have fairly unbound power to do that through rulemaking? Maybe there's some politics at play here that I don't understand, because as I said, I hate politics. The second issue I have is the substance of the proposal. If it was done through a rulemaking, I'd feel just as frustrated as if it was done through congressional lawmaking, because both of these issues would ultimately rub up against the Fourth Amendment and the Constitution. I think if you take a person who's just publishing software, and that software is used by people in the cryptocurrency space to move money, and you say, you provided a tool, software, that others are using, you are now a financial institution by virtue of providing that tool. You need to know all the people who use that tool, collect their home address, collect their social security number, and report it to government just like the bank reports on their customers. This is a radical upending of how we do regulation. Typically, we say, look, there's an agency relationship between a bank and a bank customer. The bank's acting on behalf of the customer, and the bank's transactions are their own transactions as much as their customers' transactions. A negotiable instrument is only worth something if the bank promises to redeem it. So in some sense, going to a bank and saying, give us your records, is just going to the bank, and if the bank wants to comply, they're happy to comply. This is the third-party doctrine is traditionally understood. They're not spying on their customers. They already have records about their customers, and they're sharing those records with law enforcement for legitimate purposes. But a software developer has no legitimate reason to have deep and personal and intimate information about the users of their software. So when the deputy secretary says, you know, maybe we should classify the providers of self-hosted wallets as financial institutions, I mean, the non-euphemistic way to say this, the clear way to say this, is maybe people who write software should write backdoors in their software to collect information that they otherwise have no use for in order to, I love this adverse possession concept, maintain visibility into financial flows that we think we have an entitlement to. And I want to be clear. Stopping terrorist usage of these technologies is very important, and maintaining visibility into financial flows is important. But we can't upend our constitutional system to get at that information. And would these policies even be effective? You're going to go and find every software developer across the world and say, now you're going to write your software like this instead of like that? Or are you going to focus on the large centralized intermediaries, like Treasury has thankfully done with respect to Binance, and say, look, here we can get good visibility and information, probably in a constitutional way. I'm not sure the Bank Secrecy Act is unconstitutional as applied to centralized entities.
I'm going to jump off one of your comments. Moderator's prerogative. So we did begin with the Fourth Amendment, but Peter mentioned several other kind of constitutional arguments that could be made. I'm going to turn it over to you, Paul, to think about some of these. So one, the First Amendment argument when it comes to imposing obligations on people who write code. Kind of void for vagueness or overbreadth. I also hear in that kind of a non-delegation separation of powers. So if, you know, how would you walk through some of those constitutional challenges to, you know, the broadness of the BSA, which, you know, can be used by law enforcement and agency rule writers to cover whatever they want in kind of an arbitrary way?
Sure. So let me say something about at least one of those arguments, and then but actually try to bring it back to the Fourth Amendment, because I do think some of these, you know, I do think the basic issue here is it's not exclusively a Fourth Amendment issue, but sort of at bottom, that's the provision of the Constitution where it seems like something fundamentally wrong is going on here. But the one doctrine that definitely seems, you know, potentially very ripe for application to the BSA, particularly if the administration wants to kind of not go to Congress and try to really kind of just kind of retrofit that statute for crypto, and not just, you know, sort of the first generation, but as it's evolved, That seems to fly right in the face of this so-called major questions doctrine that the court has developed over the last few years. And, I say this sort of guardedly because, as somebody who gets contacted to challenge a lot of administrative rulemakings as potentially in violation of the APA or something else, there is this phenomenon right now where, like, I don't know if anybody remembers that, like, Bruce Willis movie, The Sixth Sense, where the young kid saw ghosts everywhere, and like people are seeing major question doctrine issues everywhere. Like everything's a major questions doctrine, but this is like a classic major questions doctrine for an administration to have some big issue that Congress really should be dealing with and retrofit a statute that's been around for 40 or 50 years to sort of fit the new phenomenon. That is classic major questions doctrine material, also in some SEC issues, but we can talk about those some other time. So back to the Fourth Amendment, though. Here's to me what kind of unifies this and gets it back to the Fourth Amendment. To the extent there is this third-party doctrine, and to the extent you want to say anything nice about it, and that's not really my role, but if you want to say anything nice about it, it's designed to deal with a situation where the information in the hands of the third party is entirely organic, where it's just like this is the way this technology works. Like nobody started with how can the government get more information and then ended up with you don't have any Fourth Amendment rights. It's like, well, the telephone evolved, and then in order to get somebody on the other end of the telephone line, you had to push some buttons. And so, the telephone company had to have that information to connect you to the party on the other end of the line, and then they keep that information, and then the government gets it. But what you have in, the idea that a software developer would have to essentially completely artificially restructure themselves to become more like a traditional bank and keep a whole bunch of information that they have no organic reason to have just so they can turn it over to the government. I mean, I'll grant you that there's a species of a First Amendment compelled speech argument there, but at bottom, I think that's just a classic Fourth Amendment problem, too. It's like the government can't sort of start with the idea that we don't want to comply with the warrant requirement and then sort of regulate with that end in mind and create a situation where we're, just the most cartoonish example is, as a prerequisite to doing a banking transaction, if the government makes the bank, makes me disclose everybody I've met with in the last 24 hours, like that's absurd. I mean, of course I have a reasonable expectation of privacy in that, and it has nothing to do with the banking transaction. So the government can't sort of reverse engineer this to deprive us of our privacy rights.
And that's, in some ways, the heart of the Carpenter holding, too. People don't realize they're trading off their entire geographic movement history when they open their cell phone. And the court said that can't be outside of your reasonable expectation of privacy. Just because you wanted to use a phone, you no longer have a private location.
So we're closing up on time. I'd be remiss not to mention Tom Emmer made a passionate argument against CBDCs as a surveillance tool. So we can all go home and think about the Fourth Amendment implications of CBDCs. I also want to say it's pretty amazing that the Blockchain Association has come this far. Right? I know that this is kind of the final panel, but just a few years ago it was Kristen and a few companies that were willing to write a check, and she built all of this. And now we have lawyers like Paul Clement, who's Kristen's favorite lawyer, who kind of single-handedly stopped the Treasury midnight rulemaking with the power of his letter. The DeFi Education Fund, it's a killer organization headed by an ex-Blockchain Association staffer. They've done really amazing work, some of which they can't talk about because it's like convincing really important politicians to be supportive of our issues. And I'm just sort of super proud of it. And Kristen said, we're building the plane as we're flying it. We're building our reach, right? And it occurred to me, we had someone from Treasury come here and tell us that the banks are doing really cool stuff on AML. They're doing a pilot program where they're sharing information with each other because their systems aren't, unlike blockchains, open, permissionless, transparent. So they have to kind of find a way to share information. They're doing a pilot. It was great. But I think we have to aim for a level of political clout where we can destroy the global economy and then get bailed out. And and then foreclose on people's homes and still have government officials go to other people's conferences and brag about us. So that's our goal. Thank you.